May it please the court, Robert Stetson for First HYANNIS Realty. This is an appeal from a summary judgment in a bad faith litigation case. There are two central issues on appeal. The first is, at what point does litigation ripen into a cause of action? And the second is, what's the accrual date for purposes of the statute of limitations? As to the first issue, litigation ripens into a cause of action when either in the abusive process-like context, it is brought for an illegitimate purpose, or like in the malicious prosecution context, it lacks probable cause and is brought with an improper motive. Here, taken in the light most favorable to First HYANNIS, the facts support that the underlying three lawsuits were brought without probable cause and to, quote, bury First HYANNIS's principal, Mo Tarkano, by interfering with his development projects and his business relationships. With respect to the second issue, the statute of limitations depends on when, quote, the necessary coalescence of discovery and appreciable harm occurs. That's from the Kennedy versus Goffstein case. Taken in the light most favorable to First HYANNIS, there are two potential dates which would support that all of these claims were brought in a timely fashion. The first, again, borrowed from the abusive process context, is when First HYANNIS knew or reasonably should have known of the illegitimate purpose. That was the discovery of the Alpert email on October 15th of 2012. Or two, borrowed more from the malicious prosecution context, when First HYANNIS succeeded in the underlying litigation in July of 2014.
Mr. Stetson, let me interrupt with a question about that, if I could. What do we do with Mr. Tarkano's admission that as of the end of 2008, he was aware that Cape Cod Aggregates had changed its position to align itself with Stop and Shop to oppose First HYANNIS? Why didn't that sufficiently establish knowledge for statute of limitations purposes?
The main reason is there is a difference between bad faith litigation tactics and bad faith litigation. A bad faith litigation tactic, taking an unwarranted position within the context of litigation, it can happen in the context of good faith litigation, and vice versa. You can have good faith litigation tactics in the context of bad faith litigation. Here, it wasn't until he learned of that illegitimate purpose, the purpose to block his development projects because he wouldn't move his entranceway, that's the triggering date. And that's why there's a difference between him just knowing that, they took a position that was different than what he thought, and actually they took a position that would ripen into a cause of action. Isn't the triggering date, according to the cases, when Mr. Tarkano or First HYANNIS had or should have had knowledge of the harm, not necessarily what parties were responsible for the harm? Yes, Your Honor, that is the triggering date. And there is a difference between a loss, which is not enough to trigger the statute of limitations, a harm, which according to Black's Law Dictionary, if you look at the definition of injury, it requires a wrong or an injustice, and an actually knowledge of a cause of action. There's sort of three different levels here. A harm for purposes of the statute of limitations requires at least some knowledge of wrongful conduct. And in the context of litigation, it's a unique context to look at that in, because here, ordinary good faith litigation is certainly not actionable. It doesn't ripen into a cause of action. And you can have good faith litigation and a loss, in other words, expending legal fees or not being able to move forward with your project. But that's different from knowing that it was brought in bad faith. And that didn't happen until October 15th, 2012. There's a good example of this. We cited, as far as I know, there are no abusive process appellate claims in Massachusetts that talk about the limitation standard. But we cited, and Stop and Shop did as well below, the Watson versus Meade case. This is a mass federal court case in which it talks about, in the abusive process context, the date is the date when you knew or should have known of the illegitimate purpose. Now, that standard came from a Southern District of New York case, Duamatef, which is actually instructive. That was a then District Judge Sotomayor case, in which she found that in the context of malicious criminal prosecution, where there was a frame, where the plaintiff knew he was being framed, that it wasn't the date that the litigation commenced. It was actually the date he received a subsequent affidavit. And he learned that the reason for that frame was because of retaliation, because of his political activities. And that's similar here. Mo Tarkano believed reasonably, not only that this litigation was brought in good faith, but that he could lose. And that sort of feeds into the malicious prosecution type cases. This litigation was prosecuted for 5 years. He tried to move to dismiss this litigation unsuccessfully. Stop and Shop was represented by able and experienced Boston counsel. So there arguably was no harm in that aspect until he actually won. And there is some support for that in the Massachusetts cases. In Kennedy versus Goffstein, which I mentioned earlier, it's analogous in that was an accounting malpractice case. And there the court said it wasn't the date the IRS commenced its audit, like the filing of litigation in our context. It was actually or it could have been the date, for summary judgment purposes, that the IRS issued its notice of deficiency. And that is analogous to a judgment or a verdict. And that sort of speaks to your original question, which is, I'm drawing a distinction between, loss, harm, and then a cause of action. In the context of malicious prosecution, you may have a loss. When you win that lawsuit, then you have knowledge that the lawsuit was incorrect at a minimum. You have knowledge of some wrongful conduct. That would trigger the statute of limitations. But you may not have a cause of action because you still have to prove improper motive or illegitimate purpose. And in this case, you didn't have that until the disclosure of the Alpert email. And you didn't have that. And this sort of goes to another standard, the actual knowledge standard, which really wasn't addressed by the lower court. And you have a critical fact here that's necessary for First HYANNIS to prove with respect to all of its claims. And that is that illegitimate purpose, the ulterior motive. And that was actively concealed by Stop and Shop in the underlying litigation. They had the Alpert email.
Let me pose a somewhat far-fetched hypothetical. Let's assume that tomorrow somehow a new letter or email is unearthed that reveals yet another party that was opposed to First HYANNIS and Mr. Tarkanow and aligned with Stop and Shop and Cape Cod Aggregate. Would that then allow your client or would that provide that the statute of limitations clock starts anew based on that discovery?
I don't think so. I think that a reasonable outside date comes from the malicious prosecution context. Again, and this really is unique to bad faith litigation claims. I think at the point where you favorably won a case, you've got your loss. At a minimum, you had to expend legal fees to defend yourself, but then you have knowledge that case was improper or at least incorrect. Now, I think that is enough in most, if not all instances to trigger the harm under the existing Massachusetts case law. I think that is an appropriate outside date, and it's certainly supported in the malicious prosecution context. So I don't think, if it's 6 years after you favorably terminated, I think that at that point, the statute of limitations has run. I think there is another point, because there was a claim that was not dismissed on statute of limitations grounds, and that's the 93A claim with respect to the land court action. And with respect to that, there are two elements to every 93A claim. There's unfair and deceptive act taken in the course of trade or commerce. Now, That's regardless of whether it's litigation or some other context. Now, the Superior Court judge sort of sidestepped that analysis by citing the Morrison versus Toys R Us case. But in that case, the reference to the elements was only in dicta. That case was really about whether a self-insured company was subject to Chapter 176D. And in that, but that dicta is actually instructive on this issue, because the SJC cited another of their cases, the First Enterprises case. And there, in the context of bad faith litigation, the court stated you can have the trade or commerce element be satisfied if the defendant and the plaintiff had a commercial relationship, or if the defendant's conduct interfered with trade or commerce. Now that can happen
on that 93A claim, though. So we're now talking about the complaint, or the appeal rather, in the land court, correct?
Correct, Your Honor. That was the only one that was not dismissed on limitations grounds.
To prevail on that, don't you need to show, or doesn't there need to be some proof that the underlying appeal was groundless?
Apparently, I'm not being evocative enough with my hand gestures, because my lights in the conference room have just turned off. I apologize.
We can see you.
Thank you. The answer is twofold. We would need to prove one of two things, or both. Number one, we would have to prove more along the lines of an abusive process claim that there was an illegitimate purpose to that land court action. And we have that here in spades. We have evidence that it was brought to influence Tarkano with respect to the entranceway, it was a separate dispute entirely. There was that email from Deb Farr in 2007, which foreshadowed this very litigation, the land court litigation later on. You do have improper motive. You have Bill O'Brien testifying that there was a bleep Mo Tarkano attitude, that they would have obstructed, Stop and Shop would have obstructed anything he tried to do, even if he tried to put up a kiosk. And in terms of
let's assume, for purposes of my question, an ulterior motive for bringing the action. You still have to show that the action was groundless. And in reading Judge Cutler's decision and her analysis of the traffic issues at play, it was hard for me to discern how it could be groundless.
If it's more along the lines of an abusive process claim, you do not have to prove that it's groundless. You would have to prove that it had an illegitimate purpose. You can have good faith litigation that satisfies an abusive process claim if it's brought for an illegitimate purpose. But with respect to the malicious prosecution claims, you're right. You need to prove an absence of probable cause, number one, and you need to prove an improper motive. With respect to the land court action in particular, there was considerable lack of probable cause. Stop and Shop's own Rule 30b-6 deponent, Deborah Farr, testified, people file zoning appeals all the time. You don't win. They didn't have a reasonable likelihood of winning that case. They didn't even try. If they had gone out and hired an expert, for instance, to say that there were some traffic issues and that they were going to be harmed by them, I might not be standing here today. But that wasn't what they did. In fact, Tarkano hired the expert that Stop and Shop usually uses, VHB. And that expert said there were no traffic issues at all. And I think if Judge Cutler's decision, I think, states that they introduced no expert evidence on this issue whatsoever. So I think in that context, there was not just an illegitimate purpose, like in the abusive process context, but there is also evidence of malicious prosecution, improper motive, and the absence of probable cause. I see that my time is running down. If I can make a final point, there is a difference between bad faith litigation tactics and bad faith litigation. Bad faith litigation tactics possibly could be addressed in 231-6F or Rule 11. Bad faith litigation conduct can actually produce a far broader and wider range of harm and damages, not just legal fees. In this case, it harmed Tarkano and First HYANNIS' business to the tune of millions of dollars in lost profits. Simply asking for a finding of 231(6)(f), for instance, would have fallen well short of making him whole. Thank you.
Thank you. Now, Mr. Robinson and Mr. Beerworth are splitting your time. Is that correct?
That's correct, Your Honors.
8 minutes for Mr. Robinson.
Thank you. So let me start kind of where that ended. I think what's really important is to go back and look at the record in this case. The original complaint in this case didn't even raise the litigations. They didn't even mention the litigations. If you look at the original complaint, it wasn't about the 2009 litigation. It's not even mentioned. Or the 2011 land court case, which I'll get to, weren't even mentioned. Why weren't they mentioned? They weren't mentioned because counsel understood that if a claim was brought based on those prior 2 lawsuits, it was going to be dismissed under the anti-SLAPP statute, as his prior 93A and abusive process claim that was brought as a counterclaim in the 2009 lawsuit had happened. And so he knew, I can't mention those cases. I already tried that and I lost, and I was subject to attorney's fees in that context. I can't do that again. So it all became about this Alper email. And it became about this Alper email, which at bottom, Mr. Targano himself admitted had no legal effect, because the agreement that was purportedly required this notice and approval, and there's actually 2 pieces. One, the agreement itself had expired. Number 2, the proposed development he wanted to do was all within the confines of property he already owned. The issue for him was, I thought I had a better deal, because if I could get them to put this road in, I was going to get a 3rd slice of property and be able to put up 3 buildings instead of 2. And when that went away, he was back to his original plan, which was the BJ's and then a separate CVS, which no one ever interfered with. He could build it tomorrow. But he's running around saying, well, there's all these lawsuits, including his own lawsuit, that somehow prevents him from doing that. And the judge saw that. He understood that what this case ultimately was all about. It was, there were 2 lawsuits. Ultimately, both went to trial, which necessarily means they weren't frivolous, necessarily means they weren't abusive. And he's looking for a way to recover something because he won those lawsuits. But both lawsuits were perfectly valid. Certainly the 2009 lawsuit was definitely a valid attempt to try to align driveways that they had gone to the Cape Cod Commission and the town of Barnstable and both had said, if you want to do your development, we want that driveway lined up. Ultimately, that never happened. They had to reconfigure the whole thing. But to say that somehow them asserting those rights goes to the level of the cases that he cited about abusive process or malicious prosecution, it just doesn't hold up. But the reason the Alper email is so critical to their case, or was, and then why they abandoned it, was because it was the only linchpin they had for 2 things. 1, to avoid the anti-SLAPP motion that we were going to file. And 2, to try to drag this case forward to something that was within the statute of limitations. Once he got past motion to dismiss on that, which we obviously disagreed with, but we're willing to go into discovery and did so, then you're in a situation where now the Alper email can go away because now I'm basically in the game, because his own client admitted the Alper email and the letter had no legal effect. But now you're back to the fact that clearly by 2008, as Your Honor noted, or by 2009 when a lawsuit was filed, was Mr. Targano aware that CCA and Stop and Shop were aligned, and no pun intended, aligned in seeking the alignment of the driveway? Absolutely. And to argue that somehow, well, I didn't know their motive. Well, of course he knew their motive. Their motive was to get him to move the driveway. And in the 2009 case, even the counterclaim or the claim under 93A that Stop and Shop brought, that he tried to extort them for $5 million, that made it all the way to the jury. So to say, oh, well, but he lost, so that must mean it's abusive, that must mean there's some sort of malicious prosecution here, it just doesn't hold up. But as importantly, though, is procedurally, those claims never actually were live claims in the case. It was only at the very end of the case, when motions for summary judgment were essentially being filed, that this motion to amend to add an abusive process claim sort of arrived on the doorstep of summary judgment. And the judge rightly, on multiple grounds, said that that's not valid, both substantively, under the limitations, and procedurally not proper. Number two is they never brought a malicious prosecution claim, nor even in their motion to amend did they talk about a malicious prosecution claim. They put it in a footnote in a reply brief. And the judge rightly said, well, that you clearly can't do. So what intrigued me today about this argument, Mr. Stetson's argument, is how much time he spent on the malicious prosecution claim is really being the linchpin of how this case could survive. And that claim's not even in the case and was never even attempted to be amended to be brought into the case. So if that's his argument, this is not actually a very difficult argument for us on the defense side, because that claim was never even in the case. Quickly, on the, and I think ultimately what we're dealing with here from a policy standpoint, which is replete within the judge's decision on summary judgment, is simply bringing litigation based on prior litigation without more. That's not a valid claim. When you talk about cases like GNS Falmouth Marine or the other cases they cite, Morrison, those cases are easy because those cases are so factually distinguishable from this one. There are truly claims where someone does abuse process or has no legitimate basis. I mean, you just look at Videns versus Sudduth. That was a bunch of landowners who private property, they deemed their private park, and they spent 9 years filing frivolous litigation to keep someone from building on that property so they could take their kids for a walk and see the ocean. I get that. That's a case that should have gone that way, not this. These are two businesses, a BJ's and a Stop and Shop, who had a legitimate understanding that their driveways had to be lined up. And when Stop and Shop refused to cater to a $5 million demand to do that, they filed a lawsuit. There's nothing wrong with that. I quickly, with a minute to go, I want to address Goffstein, and I know my counsel Beerworth is going to address the statute of limitations issues more deeply. But Goffstein's an easy case to distinguish as well. Goffstein was a tax case. It's a very unique situation in tax cases because what happens is an investigation is opened. There's a discussion about the potential tax liability. And until that decision is actually made, not only is it that there's a decision, but there's also no liability yet. There's no harm, because until the tax authorities could determine there isn't a tax liability. And Goffstein details that in the tax context, where an administrative body needs to make a decision of whether or not there's even liability, obviously the statute of limitations is not going to accrue unless and until that liability is determined. Makes perfect sense. In this case, clearly by 2009, when a lawsuit had been filed saying you need to move that driveway, Mr. Tarkino was well aware, and in fact, so well aware of the claims he's trying to argue now that he brought a counterclaim in that case. So to argue he can do it, well past the statute of limitations later because he didn't understand, I guess, the motive, it just doesn't fit within the case law. So unless there's any questions, I'll cede my time and I'll turn it over to Mr. Beerworth.
Thank you. Attorney Beerworth.
Yes, thank you, Your Honor. Joe Beerworth here for Cape Cod Aggregates. I would just say at the outset that I adopt Attorney Robertson's statements and arguments on behalf of my client to the extent they apply. I too was surprised at the extent of the argument on malicious prosecution and abusive process, which are not claims in the case. The claims that are brought against my client can't relate to the litigation. And I just want to make it plain for the record that my client was not a party to any of this litigation between Stop and Shop and First HYANNIS. The only conduct that's alleged against Cape Cod Aggregates is this failure to approve in this letter of March 2006. And thinking about it in terms of the statute of limitations, then this gets to Justice Kinder, to your question about the plaintiff's appreciation of the harm. And of course, that's the touchstone, right? That's what the case is related to. That in order to rely on the discovery rule, as the plaintiff is trying to do here, they need to take it outside of the usual statute of limitations. And they need to show that they could not have reasonably learned that they had been harmed by the defendant's conduct within the statute of limitations. Now, the harm that's being alleged is this amorphous interference with my right to develop my property. That's what they say. All of this conduct is manifested in this conduct that's interfering with Mr. Tarquino's right to build on his property. As Attorney Robertson said, that's just not the case. All throughout this time period, if you just look at Mr. Tarquino's testimony, he says that he was entitled to build on his property. His development was all within the confines of his property. He says that this failure to approve by CCA in March of 2006 didn't cause him any harm because to him it was a nullity. That provision of the development agreement had expired. He says he didn't need CCA's approval in order to move forward. So in fact, there actually was no harm. And we argued that below, and I point out that we made that same argument on page 32 of our brief, that there's actually no harm caused by Mr. Tarquino by any of the defendant's conduct, and certainly not by CCA's failure to approve his sketch plan for development. But on the statute of limitations...
Let me, you may be going here anyway, but let me interject a question with respect to the statute of limitations. All of the parties spend a fair amount of time addressing the elements of the merits of the civil conspiracy and the tortious interference claims. I'm assuming, without knowing for certain, that your position is that if we adopt the judge's reasoning with respect to the statute of limitations, we don't get to any of those arguments. Is that correct?
That's exactly right. The statute of limitations is the issue that overrides it all and takes all of the, and is dispositive of all of the counts against all of the defendants in the case.
What about the 93A claim?
So the 93A claim with a 4-year statute of limitations, again, if you go through the facts as we've laid them out in the brief, and all of the instances when Mo Tarquino, as the principal of the plaintiff, knew, not just should have known, but actually knew that CCA and Stop and Shop took the same view in terms of their understanding of the development agreement and the independent contractual obligations within that development agreement. The record is just replete with those instances, and Attorney Robertson has referred to them. Even the March 2006 letter itself references the Stop and Shop development across the street and points out that it was Cape Cod Aggregates' understanding that Mr. Tarquino's driveway needed to align with the Stop and Shop driveway. The development agreement is then assigned to Stop and Shop, and Stop and Shop's lawyers in 2008 send 2 letters in July of 2008 and December of 2008 to Mr. Tarquino, making arguments, analyzing the development agreement and saying, you need to move your driveway. That's what this development agreement says. So he knew these things in 2008. He certainly knew them in 2010. Justice Kinder, I think your question related to the airport meeting between Sam LaRusso and Mo Tarquino, where they had a conversation. Mr. Tarquino testified at deposition that he took away from that conversation that Sam, Mr. LaRusso, had shifted his position to align with Stop and Shop. I would submit it's not a shift. It was always Cape Cod Aggregates' consistent opinion, and that's borne out in the testimony of Dave Peterson. But nevertheless, Mr. Tarquino certainly understood it. So culminating, of course, in the lawsuit. And the last act that plaintiff even points to at all that Cape Cod Aggregates undertook was to submit affidavits. Mr. Peterson and Mr. LaRusso submitted affidavits. But again, those were 2010. So by 2010, it was perfectly clear that Cape Cod Aggregates took the same position as Stop and Shop did in the litigation. There it is in the affidavits. There's nothing false, I need to say, about those affidavits. They're my client's view of their understanding of the agreements, supported by the evidence that's in the record. So by that point in time, the statute of limitations certainly had accrued. I would direct the court's attention to the Harrington versus Costello case, which I think is akin to this fact pattern in the sense that it was a defamation case, and the plaintiff in that case knew that the allegedly defamatory publication had been made, knew who had published it, but it wasn't until later on that he discovered that there was some ill will some motive here. And he tried to make the argument, the plaintiff in that case, that took the case within the statute of limitations because he couldn't know about his cause of action. And the court there, the SJC, said, no, you don't need to know your legal theory. You don't need to know that it's going to be successful. You don't need to have all of your evidence. What starts the accrual is the harm. And for Mr. Tarquino, look at the complaint. Look at paragraph 39 of the complaint. It's alleged plain as day that sending of that letter in March of 2006 was the harm to him, that interfered with his development rights somehow. Somehow, I don't know. But he says that was the date that harm accrued to him. And that should start the statute of limitations. So okay. If your court has any questions, I'll be glad to entertain them.
Seeing none, I thank you all, and we'll take this under advisement.
Thank you.
Thank you very much.
Thank you.
Thank you.